This event and the partnership between OHADA and NICArb as a whole is a true example of the fact that Africans can collaborate irrespective of their background, their language, or their culture. Those differences are also at the core of this event. You already know the theme of the event. And that leads me to the second reason of the importance of such an event. The wider Common Court of Justice and Arbitration is the Supreme Court for 17 African countries, as I said, in matters of business litigation and arbitration. The court also supervises an arbitration center. If you allow me to make a brief incursion into centers, operation, and news, I'd like to inform you that with the aim of increasing its autonomy, efficiency, and credibility, new internal regulations have been adopted in October 2023, and a monitoring committee has been set up, removing the court's prerogative for administering proceedings. That said, over the 17 countries the Common Court covers, 15 are French-speaking with civil law inheritance, culture, and practices. It is not different when it comes to arbitration. Though international arbitration is becoming global with more or less same principle worldwide, it remains that practice is greatly influenced by legal culture or legal inheritance. That's why navigating the international arbitration landscape necessarily means examining the differences and exploring possibilities of an harmonization. To that effect, this event is spot on, and I see no better actors than organizers, NICArb and OHADA, to carry the torch of this kind of harmonization, or at least to try to reconcile what is the best from both sides for the betterment of international arbitration in Africa. I must just emphasize on the fact that OHADA has 4 working languages. French, English, Spanish, and Portuguese. You can understand why, far from being a simple gathering of professionals accustomed to discussing international arbitration issues, this event aims to be thought-provoking, preparing younger professionals to future challenges of different practices and sharpening the skills of experienced professionals. Special greetings to the other panelists who accepted to join the discussion. Thanks to Professor Olajide Olagunju. Thanks to Mr. Jos Bayo. Thanks to Dr. Francis Olege. And thanks to my beloved brother, Dr. Achille Gwanza. We greatly appreciate your implication and your contribution. To all of us, speakers and listeners, I wish I enriching meeting. And to OHADA and NICArb, I wish a very, very fruitful and lasting relationship. On these few words, I declare open the first joint webinar organized by NICArb and OHADA on the theme exploring the harmonization of arbitration and ADR practices across common law and civil law systems in Africa. And I give you thanks for your kind attention. Merci.
Thank you, Madam President, for that very striking opening remarks. It's my pleasure to invite my dear brother and friend, Dr. Carol, to please give a warm address. Dr. Carol, I know you had said you had prepared for 10. Please, could you just spend 5 minutes to give the welcome address so that we are able to have enough time for the speakers and the participants, and we can bring you back on I know you have a lot to share with us. Thank you, Dr. Carol.
Thank you, Shola. Are you listening to me?
Yes.
Okay. Madame la Présidente de la Cour commune de justice et d'arbitrage, I will speak in English, maybe because there will be also some panelists speaking in French and others speaking in English. So estimate Madame President of the Common Court of Justice and Arbitration, Madame Chief Registrar of NICArb, distinguished panelists, Mrs. Justice Bayo Dasundo, the lady, Professor Olajide Olagunju, Dr. Francis Olegue, and Dr. Ngwanza, esteemed Director of OHADA, Common Court of Justice and Arbitration, and ESUMA, all protocols observed, Mr. Secretary General of the Arbitration Center of CCJA, ladies and gentlemen, distinguished African legal community and arbitration practitioners and mediators from across the globe, welcome. Welcome to this joint webinar. And I would like to start by asking us to look around us and first acknowledge the richness of our legal traditions. The diversity of our mixed legal systems are not, in fact, barriers. They are not legal barriers. In fact, they are, let's say, distinctive elements that makes us unique. Let us then see the immense potential that lies in the harmonization. This is the reason why we are having this joint webinar. Today, we are not simply gathered to attend a webinar. We are the architects of a bold and bright vision, the one of a more coherent, more accessible, more attractive, and therefore more useful African legal space for the development of the African continent, a more impactful legal space for the future of the African continent. That's what we are trying to do here. That's what we are defining. We are defining the new boundaries of a new dynamics, the one of harmonizing ADR practices, alternative dispute resolution practices within legal, civil law, and common law system in Africa. ESUMA, NICArb, the Common Court of Justice and Arbitration, through its arbitration center, have conceived and implemented this. And this is not the first time. As the chairwoman of the Common Court of Justice and Arbitration said, all of this has been ongoing since the MOU between NICArb and OHADA, and especially Common Court of Justice and Arbitration. We have been participating to mutual events together, such as the annual conferences of NICArb, particularly the 2023 NICArb annual conference, focusing on repositioning the arbitration and ADR practices in Africa, and in which all the organizers of these intellectual gathering participated. This was followed by official working visits to Port Novo by NICArb and many exchanges that we did together, and also the African Arbitration and Mediation Days in Abidjan, organized by the Common Court of Justice and Arbitration, and the Libreville edition conducted by under the leadership of ESUMA. And now this conference. I cannot mention many other activities that we do together and we did together and continue doing together. Many other actions, and we are planning also under the leadership of Mrs. Esther Mutungi-Ikwe, the African Arbitration, Justice and Commercial Information Week in Benin. You will hear more about that soon. We aim to reposition ADR in Africa. We aim to train more people from African background, a generation of seasoned and experienced practitioners in accordance with the international standard and leading international arbitration hubs. To achieve this, the Regional Higher School of Magistracy, in that dynamics, launched 2 years ago an international certification program on arbitration and mediation, OHADA and international perspective. These certifications are conducted completely online, and they are done with evening classes and offer the possibility of asynchronous learning. So you could more be able to conciliate your work-life balance and continuous skill development. We do many actions here at ESUMA, but this is not the place to go deeper on that. With NICArb, it is in fact a permanent engagement. It is a permanent engagement because that engagement is a period where it is the best time when you are working together. Because when you go to marriage, after the honeymoon comes routine and sometimes problems. So we are in that constant state of engagement. And this is how it is for me an immense pleasure to lay another cornerstone of this edifice with Shola Oshodi John as the registrar of NICArb. Shola, thank you very much for your implication. But this has also been made possible thanks to the decisive support of our elder chairwoman, President Esther Mutnigi Ikwe, Honorable Judge of the Common Court of Justice and Arbitration. Despite her health condition, she has done everything to participate to this joint webinar. Mrs. President, thank you also. Thank to all the parties involved in the organization of this event. And I could stop there because Shola asked me to talk only for 5 minutes, but I still have 2 minutes. 2 minutes maybe to dwell a little bit further into the subject that brings us together. Let's talk briefly about the context, about the opportunity, and finally the action. The context, I already mentioned it. It is uniting legal professionals, especially arbitration practitioners beyond tradition that may seem to divide us. In fact, it is a mirror perception. It is a misperception, as from on another angles, the ultimate goals are the same. When you have a seller from Lagos and a buyer from Cotonou, even if it is common law system and civil law system, when they want to sell and buy goods, they don't take care of common law or civil law. They just want the same objective and they work on it. When the dispute arrives, there is no real differences between their goal. They just need a prompt, effective, and efficient solution, no matter what consideration you take into account, no matter who will be the lawyer or the judges in charge of the disputes. So the coexistence of civil law and common law system in Africa is in fact a source of both richness and opportunity for us. The challenges this situation can create for litigants, legal practitioners, and economic development of Africa is highly mitigated by OHADA. This is the moment we can also thank the authorities of OHADA for what they are doing. I explained those situations last week during the weekend of mining law in Conakry, discussing with Nigerian and Ghanaian lawyers about the opportunities that arbitration could bring as a bridge to help the harmonization between the system. And this is why we are here. It is for a pan-African approach. It is the way to overcome some obstacles and strengthen, in fact, legal integration as a foundation of economic integration. The opportunity of ADR will be highly presented by our panelists, and I will not go further on that. This webinar, in fact, is a catalyst for change. It's a call to action. It's bringing together key players such as CCGA, Nigerian Institute of Chartered Arbitrators, SUMA, the Center of Arbitration of CCGA, and many other key point players. So we would like to thank the speakers, to highlight their expertise, and to wish you a very welcome participation to this event, where we are trying to build the future of Africa within the ADR, within the legal space we have. Thank you, Shola. I hope I did not go more than what you gave me as a time. Thank you, and welcome again to everyone to this joint webinar.
Thank you so much, Dr. Carol. Anyway, you told me you were going to use 10 minutes and you actually used your time. So, okay, once again, welcome everyone. Good afternoon, good evening, and good morning to our esteemed participants joining us from all over the world. My name is Shola Oshodi John. I'm the Registrar and Chief Executive Officer for the Nigerian Arbitrators. It's my pleasure to moderate today's important webinar on exploring the harmonization of arbitration and ADR practices across common and civil law systems in Africa. We are privileged to be joined by an exceptional panel of distinguished experts and jurists I wouldn't go at this point mention names, but as we go along, we will do a proper introduction of each speaker. Today's webinar represents a meaningful collaboration among three respected organizations, an embodiment of Africa's growing commitment to building a cohesive legal and business environment. Together, we are examining the urgent need for harmonized reforms and greater uniformity in arbitration and ADR practices across common and civil law systems. These reforms are not merely academic, they are vital to facilitating cross-border businesses, promoting investments, and enhancing legal certainty across the continent. We thank you all for being part of this critical conversation, and I encourage you to actively engage with today's discussions and share your question and insight via the Q&A function too. So let me at this junction invite Professor Jide Olagunju, our speaker for today's webinar. Is going to be discussing the area of convergence and divergence in arbitration and ADR practices between common law and civil law systems. I can see that Professor Olagunju is ready, so you have the floor, sir. You don't want to waste time. Go ahead, sir. You have the floor.
Bonjour, Madame President, mes co-panelists, tout le monde. I welcome everybody. And I'm glad to be here. This is great for Africa. And I know that because of the dedication of everybody, it will go well. I have just 15 minutes, so I'll be very quick with the business I have to do. So let's go into what we have to understand from my perspective, and then we'll have a discussion. So that's the topic, and that's me, and that's my email in case you need to reach out to me. Now, areas of convergence and divergence in arbitration and ADR practices between common law and civil law systems. I have two introductions. The international arbitration has evolved as a system for resolving disputes among parties from different countries. Not surprisingly, those parties tend not only to use different languages, but also to approach dispute resolution from the perspective of very different legal systems. The two most widespread legal systems are the common law systems in use in most English-speaking countries and the civil law systems in use in continental Europe and the many countries around the world influenced by continental Europe, from Japan to most of Africa and all of Latin America. The common law and civil law differ significantly in how a dispute is commenced, developed, and presented. Forgive me. In arbitration and ADR practices, both common law and civil law systems exhibit both convergences and divergences. While both systems embrace arbitration as a form of ADR, differences in procedural approaches, evidentiary rules, and the role of the arbitrator persist. Key areas of convergence include the general principles of arbitration, such as party autonomy and procedural fairness. However, divergence is evident in how evidence is presented, the role of witnesses, and the level of formality in the proceedings. Now, areas of convergence, I quickly list them. General principles, both common law and civil law systems generally agree on fundamental arbitration principles like party autonomy, allowing parties to agree on the terms of arbitration, the need of procedural fairness, and the importance of arbitral impartiality. Purpose of ADR, both systems utilize ADR mechanisms, including arbitration, to resolve disputes outside of traditional court proceedings, aiming for efficient and cost-effective dispute resolution. Arbitration as a private process. Both systems recognize arbitration as a private, confidential process where parties agree to resolve their dispute through an impartial decision maker rather than a public court proceeding. Enforceability of arbitral awards. Both common law and civil law systems generally enforce arbitral awards provided they comply with the terms of the arbitration agreement and relevant legal rules. Now, areas of divergence. Procedural formalism. Civil law systems tend to be more formalized and prescriptive in their procedural rules, while common law systems offer more flexibility and allow for greater party autonomy in structuring the arbitration process. Evidence and witnesses. In common law, there's a greater emphasis on broad document discovery and cross-examination of witnesses, while civil law systems often rely on a more selective approach to evidence and tribunal-led questioning. Role of the arbitrator. Common law systems tend to view the arbitrator as a neutral referee, while civil law systems may see the arbitrator as having a more active role in guiding the proceedings and potentially taking a more inquisitorial approach. Use of documents. In civil law systems, documents are often presented in advance and considered self-authenticating, while common law systems may require live witness testimony to authenticate and explain documents. Discovery. Common law systems often feature broad discovery, where parties request a wide range of documents from each other, even if not directly supporting their case, while civil law systems tend to require a more targeted approach to document production. Appeals. Common law systems generally provide for more limited appeals of arbitral awards, while civil law systems may offer broader grounds for appeal. Treatment of consideration. Under common law, consideration is critical to contract enforcement, except for contracts witnessed by deeds. On the other hand, there is no need for consideration under civil law. Principles of law. Judicial precedent is the basis of common law, while civil law is based on legislation. That's a very, very important, or probably the most important. I want to move quickly to bridging the gap. And you read the data, so I'll just skip a lot and go to number 8. So, okay. Forgive me. I'm sorry. In trying to be fast, number bridging the gap. Yes, this is where I want to go. So, an international arbitration with participants from each side of the common law, civil law divide has traditionally required arbitrators to follow the practice of one party or the other at each stage of the arbitration. In recent years, however, converging practices have emerged that embrace elements of both systems. These converging practices are rapidly gaining acceptance in international arbitration as a middle ground acceptable to parties from both sides of the divide. And I went on to state all the various efforts to bridge the gap, including the intervention of IBA and all that. Bridging the divide. Yes. So I see the major bridge between the two systems in the adoption and the acceptance of both common and civil law systems by both of them, by the acceptance of the various UNCITRAL model laws, procedures, uniform laws, coordination and as well as coordination and cooperation in both arbitration and ADR. The rationale for adoption of the UNCITRAL processes is because all legal systems, whether common law, civil law, and the others, are both stakeholders. They are all stakeholders and contributors to the outcomes of various UNCITRAL activities to support international trade and economic development to the benefit of all. And I see the trend of collaboration and cooperation continuing not only at the level of UNCITRAL, but also multilaterally and bilaterally, which is why we are privileged to have this meeting we are having today. I also see in the 2018 agreement established in the African Continental Free Trade Area, AFTA, which came into force on May 30, 2019, a further strengthening of the Pan-African convergence of common and civil law systems in arbitration and ADR practice. Since we have agreed to trade freely across our borders, the practice of arbitration and ADR, which are essentially tools of business and trade, should naturally become borderless. In terms of practical implementation of integration for convergence, a low-hanging fruit is the existence of 100 African arbitration institutions and allied organizations such as the NICArb, OHADA, AFSA, CCJ, CISRICA, OAMCC, KIAC, LCA, NCIA, ICNCI, CAMA, and of course the various CI branches across Africa. All those African arbitration and ADR institutions and initiatives must work more together, leveraging technology as well as AFTA and OHADA conventions to form the base for building the convergence of arbitration/ADR practices across the African continent. I know that OHADA and NICArb are already leading in this respect with their strong connections and networks with some of these sister organizations across Africa. Bridging the gap. Well, you can read more later. I want to move on to my conclusion because I think my time is about running up. Our very similar African dispute resolution mechanisms, which predated colonialism and are healthier than colonial-based litigation. While litigation is adversarial, African dispute resolution stresses relationship and inclusiveness. This is very important for us because I am a student of traditional African dispute resolution. And I've noticed that traditionally what we do in Africa is essentially the same thing, which are metaphors for convergence and inclusivity. When we integrate African dispute resolution into the already adopted UNCITRAL models and leverage several other opportunities, some of which I have listed in this presentation, modern-day African arbitration and ADR could become more convergent and seamless. To achieve this goal, African arbitration/ADR institutions and practitioners must, and I'm speaking to everybody listening to me now, each of you is important, must be ready to learn traditional African dispute resolution mechanisms, teach them to their clients and students, and most importantly, practice them. They must also closely collaborate among themselves to leverage the opportunities for integration and inclusivity presented by various UNCITRAL and African conventions and agreements, as well as internet technology and Africa's closely knit topography. That's my little offering for you today, and I'm very grateful for your attention. Thank you so much.
Thank you so much, Professor Olagunju. That was apt. The key takeaway points for me was the last one you said, which I think is something that we also have to be considering. How do we get UNCITRAL to integrate African dispute resolution mechanism in its model law procedures and every other rules as we know them to be? At this junction, the floor is open to our panelists. If anyone wants to make a contribution and add to what Professor Olagunju has said, the floor is open. But we have 3 minutes to wrap up this section. So if any of the panelists wants to take the floor, please signify by using the hand raise button or just raise your hand physically, and I will call on you to make your contributions or comments at this juncture. While we're waiting for the comments to come in, I also wanted to add the fact that Professor Olagunju has touched on a point that is very important to us, and that has to do with relationship and inclusivity in Africa. We need to begin to relate more, and this is what this webinar is all about. And Dr. Archie, you want to say something?
No, I don't have any comment.
Okay, so this is what this webinar today is all about, the need for us to really begin to implement and converge as one. Yes, we know the civil law and the common law systems is an issue for us, but with the presentation today by Professor Olagunju, we have seen that there is a middle point. And I want to encourage us to begin to think about how to explore the middle points where we can embrace elements from both systems, you know, the middle ground that's accessible to all of us, so that we don't have a situation where we just talk about, oh, we have civil law in Francophone speaking countries, we have common law. But that's one area where I'm very, very, very proud of Cameroon. Cameroon, and I'm jealous of Cameroon because Cameroon has the privilege of having practice dual system. They practice both the common and the civil law, and that's one area that we all can learn from. I see Dr. Achi smiling. So this is something we need to look into and begin to think of. How do we exploit what Cameroon as a nation has and learn from it to be able to move forward in terms of trying to unify the both systems and be able to operate in any of the jurisdictions that we find ourselves in. So if there's no comment, I'll move on to the next panel, the next speaker. We'll move on to the next speaker. We have our second speaker, we have Dr. Achi Wanza. Dr. Achi is going to be speaking on the role of arbitration and ADR in facilitating business and investments across Africa. And once again, Dr. Archie, I want to say my sincere condolences to you on your bereavement. And I want to also, on behalf of 3 institutions, thank you for being here today. I know it must have cost you a lot to make it to this webinar. Thank you so much. We appreciate it.
Thank you for giving me the floor, and thank you to OHADA and NICArb for inviting me to this interesting conference. Shola, you know all my involvement and my commitment for building a bridge between jurisdiction in Africa in terms of arbitration practice. I have to address the issue of the role of arbitration in ADR in facilitating business and investment across Africa. Due to the time limit, the time constraints, I will go straight to the issue. Addressing the issue for me means focusing on 3 questions. On the prospect of business lawyer, when you are in the decision-making process, you have 3 questions. The business climate of the country are going, the performance of the contract, and the settlement of dispute. Even you also have to focus on securities. I will not address this point. Let me go first on climate business. All people will remain that World Bank were made a ranking of secure destination for business in Africa for secure jurisdiction. Amicable dispute resolution and arbitration was one of the most important criteria to assess if you can do business safely in a country. So, since the 3 last decades, we saw a huge movement to enact or amend arbitration and amicable dispute resolution legislation. Why these countries see the needs to enact new legislation? Because for foreign investment and also for domestic investment, of course, it's very important to make sure that in case of dispute, you can have a system, an adequate system, an accurate system to settle dispute. And you know, not only due to the lack of seniority of national court, there are several issues we can discourage any investment to go to some countries. For example, when you know that due to bribery, due to lack of expertise of judges from some particular issue like construction, international investment, you don't want to go to national court. So arbitration and the practice and the development of arbitration in a jurisdiction is a good point for the assessment of the business climate. So practicing arbitration, developing mediation, and any amicable way to settle dispute is very important for the decision process making. So this is the first point. And the second point is the performance of the contract. We know that even you enter an agreement to make a transaction, to realize an investment, a dispute can arise. How will you settle the dispute? First of all, we see from there over the years how mediation is growing up in all area in the world in commercial dispute. Why? Because it's the best way to protect the business, is the best way to continue the transaction. So everywhere, when you are an investor, you plan to inject your money in a market. The first thing you are checking, if you have a dispute, what is the influence of a dispute on the performance of the contract? If you can settle the dispute amicably, that means you can continue your business because you reach an agreement that a decision we can create a huge tension between the parties. So amicable dispute resolution is very important for the performance of the contract, because even the party does not agree on one point, they can enter a negotiation. They can also have a mediator who help them to negotiate the settlement of the dispute. Is the main reason for why the OHADA lawmaker 8 years ago enacted a uniform act of mediation, because they realized that it's not all kind of dispute who can be settled in arbitration. Sometimes it's better to enter an agreement. The impact of arbitration of the performance of the contract. Generally, people consider that when you are going to court, that means the business is finished and you cannot. But arbitration one have most advantage, the confidentiality. When people have a dispute, the confidentiality of arbitration protect the reputation of the companies, the reputation of the people involved in the dispute. The confidentiality is also an advantage because beyond the reputation, you protect the business secret. And it's very important for some kind of dispute when you have intellectual property. You have, when you have a state involved in some contract, it's very sensitive for the state to protect some secret related to national defense. So the confidentiality is one of most important advantage of arbitration. And that means even the parties are involved in a dispute, they continue to make the business, and they continue to make the business because they protect the existence of the dispute. Nobody knows that they have a dispute first. They protect their reputation. They protect the business secret, and it's a great advantage. The last one is the settlement of dispute. Obviously, when you are talking about ADR or arbitration, you are talking about settlement dispute. But why is an advantage? It's an advantage because, first of all, the most important need of business is celerity. When you can settle your dispute swiftly, that means you mitigate the damage of the dispute, and you can also negotiate an alternative transaction if you don't want to continue with your previous partner. The second thing is the expertise of arbitrator, of mediators. Generally, people appoint in arbitration or as mediator are people who have a good knowledge of the business area. It's very important to understand the issue at stake, because sometimes to issue the best decision, you don't only have to focus on the legal perspective, you also have to understand the business model of the contract. And that means you don't need only national judges, you need people who are really involved of the area when the dispute arose. This means, if I can summarize my presentation, how arbitration and amicable dispute resolution facilitating business on 3 ways. First of all, giving confidence to anyone who wants to invest in Africa is the reason for why the majority of lawmakers now enact or amend arbitration regulation. The second way, for the performance of the contract, amicable dispute resolution arbitration are confidential, that they protect the reputation. You know that in many jurisdictions, in particular in civil jurisdiction, the hearings are public. There's no confidentiality, and everyone can enter and hear what is happening. You see many news relate this kind of dispute, but in arbitration is not regular. Secondly, beyond the reputation, arbitration in terms of celerity is the best way to mitigate, and also mediation, of course, is the best way to mitigate the damage of the dispute. So finally, is not a fashion legislative behavior to adopt or modify regulation related arbitration. Is a huge strength who confirm that if you want to increase the business in your country, you have to implement a strong and pragmatic practice arbitration and alternative dispute resolution. I think I respect the time constraint, and I'm open to the question.
Thank you, Dr. Achi. Thank you so much. And I like your parting words with us. The parting words you left for us, which is that if you want to increase the business in your country, you have to implement a very strong and robust arbitration and ADR practice and regulations. And I think this is where we need to look at it more, to ask ourselves, do we have that in Africa as of today? And I would say, yes, we do. And so it definitely means that we need to now think about, which is what we're doing now, how do we connect the dots to ensure that the various countries that already have very strong arbitral ADR parties are able to function effectively and just have the practice just there, and there's nothing that is coming back to the practitioners in our individual countries, either because the wrong perception, or even because of the way and style and manner in which our own political leaders in the governance space tend to run the business of our individual countries. And so I'd like to open the floor and say, if we have any panelists that wants to make a contribution at this time, or raise under the question, the floor is open. We have 3 minutes for this. We need to take our panelists' questions and comments to Dr. Archie's presentation. Okay. Judge Bayo, you have the floor.
Thank you for giving me the floor. Thank you, Dr. Ngwanza, for his speech on the role of arbitration and ADR in facilitating business and investment across Africa. And the main point was arbitration and ADR are strategic enablers of business and investments on two ways. The first way, which is the confidence given to the investors, and the second way, which is the confidentiality, the celerity linked to that means of resolution dispute. Having said that, my question, I'm just wondering if our ADR centers are effectively functioning till now toward this goal.
I'm sorry, Judge Bayo, could you please put on your video?
Oh.
The audience would like to see you. Thank you.
Yes.
May I respond now, Shola?
Can you hear me?
Yes,
can you
yes.
see me as well?
And I get your question.
Okay, if you get my point, then I give you the floor back.
Okay.
Thank
so you
you,
became the moderator.
I'm not. Mrs. Swara is.
Go ahead.
There are two issues in the question because it depends if we are in a domestic prospect or in international prospect. In the domestic prospect, of course, we need to strengthen the practice of arbitration by training people, reinforcing the capacity, promoting arbitration EDA to the business, to the lawyers, to all the people who draft contract in order to set arbitration agreement. In international prospect, the situation is a bit different because in all the contract signed by African citizens and foreign investors, they are used to insert arbitration agreement and amicable dispute resolution agreement. Now, it's not a big deal to negotiate it. All countries are familiar with the fact that when you have a foreign investor, he don't want to go to the national court. The main problem is our capacity to handle international arbitration. That's why this conference is very important because the main topic of this conference can be summarized in one word: a bridge. We have to build a bridge between our countries. Why? The previous speaker was talking about the difference between common law and civil law. For example, cross-examination of a witness. For civil lawyers, we don't have any experience because it's not our system. We have to learn about the Nigerian and the other English-speaking country, how to prepare a witness for cross-examination because they are familiar with the system. And the reverse is also true for other rules of arbitration. So for me, it's clear that it's not enough to enact regulation, law on arbitration. We need also to increase the practice, but enacting this law was the first important step. I don't know if I replied to the question, Mrs. Bayo.
Yes, thank you.
You're welcome.
I agree on the bridge.
Thank you, Dr. Archie. Thank you so much. And yes, you said something that is very important. I wanted to just quickly highlight, and this is the fact that our capacity to handle international arbitration. What I think is lacking is the arbitration matters itself. Because like we all know, arbitration is more about practice. And so if arbitration matters at the international arena are being found out to arbitrators from other continents, of course, definitely, we're not going to be able to develop that high level capacity that is required to be able to represent ourselves. So this is an area that we all need to take back home, to go back to our various policymakers, political leaders, Ministry of Justice, honorable ministers, and to the generals. Let them know there's a need for us to now begin to build capacity within, not just about training. We've gone beyond the level of training. We have trained so many. For instance, we have trained over 8,000 arbitrators, and I'm sure other institutes as well have trained so many. So if it comes to training and the skills, we already have arbitrators, practitioners that have the needful skills. So we need to look at this area because this area is critical for us. So if we don't have capacity in particular areas in Nigeria, for instance, then we can go to Cameroon, shop up somebody that has, rather than going across the continent. So this is part of what we're talking about with today's webinar. So I'll proceed now to the next speaker. Permit me to invite Dr. Francis Olege. Is going to be speaking to us about enforcement of arbitral awards and settlement agreements across jurisdictions. Dr. Olege, you have the floor.
Laura, let me say a final word. Due to my particular situation, I will leave the conference.
That's fine. Thank you so much for honoring me. Thank you. We appreciate you. Bye-bye. Dr. Olege, you are muted. Can you unmute, please?
No, I've seen it. Thank you so very much for this opportunity given to me by OHADA and NICArb to participate in this very important webinar today. I'll be talking on enforcement of arbitral awards and settlement agreements across Africa's common law and civil law jurisdictions. By way of a very short introduction, the focus of this topic really is to examine or ascertain the status of enforcement of arbitral awards and settlement agreements in the common law and civil law jurisdiction across Africa. And I must say that it is not as bad as it used to be. Quite a lot of improvements, have occurred in both jurisdictions. Arbitration has remained the preferred option in resolving cross-border commercial disputes because, of course, arbitration is very amenable to, because of its amenability to determination. Businessmen, commercial men, they are really not too concerned about negotiating when there's a dispute. Many of them would rather want a third-party neutral who would give a decision as to their rights and the liabilities of the opponent. And so arbitration is still very much around. It's very amenable to determination. Commercial disputes are amenable to determination. Parties want to get a decision on their disputes. Of course, also, before now, it is only arbitration really that had a mechanism for recognizing and enforcing the outcome, of the process, even if it's from a foreign country. Of course, the story has changed now with the Singapore Convention that now allows the enforcement of settlement agreements, from foreign countries. Arbitration also, provides parties with finality of process. Once parties agree to arbitrate, then of course they must continue with the process. They cannot stop the process at any time, unlike mediation, where it is possible to agree to mediate, but of course, any party can walk away at any point before there is an outcome. So these factors actually have made it possible for commercial men to still lean toward arbitration more than to any other form of ADR, even though, of course, mediation is gaining grounds now, as at now. Let's now come to enforcement of arbitral awards before we now come to enforcement of settlement agreements. Enforcement of arbitral award across these two jurisdictions. There is, of course, the common denominators that Professor Olaguju mentioned earlier. The New York Convention is like a unifying force, as well as the UNCITRAL model law on arbitration. As at today, all the English-speaking countries in Africa have adopted, have ratified, or acceded to the New York Convention. So as a result of this, the fact that many African countries are parties to the New York Convention, and then many African countries also held their arbitration laws after the UNCITRAL model law on arbitration, there is a common ground. There's a common denominators in these two legal instruments for Africa. So you see some similarities here and there, even though the systems are different, but with the New York Convention, that provides an enforcement mechanism for foreign arbitral awards, and the UNCITRAL model law on arbitration that provides a guide as to harmonizing arbitration practice all across the globe. There is some similarities in these two jurisdictions. Then, of course, there is this, the New York Convention is actually based on the principle of reciprocity, which means that for a party to enforce an award in a country, the country in which the award was made and the country in which the party seeks to enforce the award must both be parties to the New York Convention. And of course, this is also, you find this also in Section 60 of the Arbitration and Mediation Act of Nigeria and several other laws in both jurisdictions. However, it's very important that we compare, that principle of reciprocity with Nigeria's, the AMA of Nigeria, Section 57. Section 57 of that act provides that irrespective of where an arbitral award is obtained, that award can be enforced in Nigeria. So Nigeria has gone far beyond the principle of reciprocity to say, yes, we are party to the New York Convention, we recognize the procedure under the New York Convention, but beyond the procedure in the New York Convention, any award from any jurisdiction, whether that jurisdiction is a party to the New York Convention or not, will be enforced in Nigeria. Now, let's now look at specifically enforcement regime in Africa's common law countries. We'll be looking at Nigeria, Ghana, Kenya, and Rwanda. We'll be looking at their unharmonized arbitration and enforcement regimes. Of course, we know that the civil law country represented by OHADA, have been able to harmonize their arbitration law, unlike the common law countries that still have unharmonized system. Like I said, the New York Convention is applicable to all, even in all these common law countries in Africa. They've all acceded to the New York Convention. So each state party recognizes each state in the common law countries in Africa recognize arbitral awards as binding, and they enforce them according to their local laws. That is where the divergence now comes in. They recognize arbitral awards as binding, they enforce them, but they do so according to their own local laws. It's not very obvious, the literature before now is, African countries are not pro-arbitration, they are not pro-enforcement, the courts are not cooperating, cooperative enough, and so on and so forth. That was very legitimate. But Africa has moved away from that now. The Arbitration and Mediation Act, for instance, is very pro-arbitration. Like I mentioned earlier on, the Act provides, look, even if an award is made in a country that's not a New York Convention country, the award can be enforced in Nigeria. So Nigeria is pro-arbitration now, pro-enforcement. In fact, the Supreme Court in Makwenye versus Imokwede said it very clearly that Nigeria is pro-arbitration friendly. And of course, they've shown it over the time. In fact, in that particular case, the agreement had a major problem. The agreement parties nominated a non-existent appointing authority. But the courts, had that, look, even though the name supplied by the parties is not known to law, but the parties knew the arbitration institution they were referring to. And so, even though there was the arbitration clause was defective, the court went on to say that since parties know the institution being referred to by them, that arbitration clause was good enough. And so they upheld the arbitration clause and allowed the arbitration to go on. That is how far the courts in Nigeria have gone. To say, yes, there may be defect in this clause, but if the intentions of the parties can be known from all circumstances, of course, that clause will stand. So you see, they are very the Nigerian courts are now very pro-arbitration, and not only Nigerian courts, like we'll see in other, when we look at other countries, virtually all countries in Africa now, their judiciaries are very pro-arbitration, pro-enforcement. A one-time CGN of Nigeria, Honorable Justice Onoe, gave directives at a time that, look, that was in 2015 or so, that all courts must give effect to arbitration clauses or agreements and refer parties to arbitration. It was a very clear directive that he gave on that matter. And that has been the stand of the Nigerian judiciary since that time. Now, once there is a clause in a contract for that parties will resort to arbitration, then they must go to arbitration unless there's any reason why they shouldn't. For instance, if the agreement is against public policy or one of the parties lack capacity to have entered the agreement, then of course the court will not allow parties to circumvent the arbitration. If not, the courts now favor arbitration, support arbitration, unlike what used to happen some 10, 15, 20 years ago. The AMA also has made provision now. The other challenge was, okay, our courts are pro-arbitration, they are supportive of the process, but lawyers go to court in Nigeria, especially in Nigeria. Lawyers go to court on everything. Every award, lawyers want to set aside every award, no matter how good it seems, no matter how good it is. The AMA has solved that problem. The AMA has been able to bring us to a position where, since our courts now support arbitration, then the law is trying to also stop lawyers in Nigeria from frustrating this wonderful process by introducing what we call arbitration claims and appeals. What they mean simply is that any application relating to arbitration matter, any application at all, whether application to set aside, application for enforcement of arbitral awards, application for application challenging jurisdiction that goes to court if it ever has to go to court, application to stay proceedings in the court. All these applications are now regarded as arbitration claims. And the law has provided expedited timelines for all these claims to be heard. Like I said, the challenge was, yes, the courts are pro arbitration. Yes, the courts are pro enforcement. But when an award is made, a lawyer rushes to court, stays in the court at the High Court for years, from there, cross to the Court of Appeal, stayed there for a longer time. And then, of course, before the matter gets to the Supreme Court, you are talking about 10 years and above. And you know that an award, an award that one got 10 years ago, the value of that award can never be the same today. So that was a major challenge, but the AMA has addressed that to say, if there is an application relating or regarding any matter, any arbitration at all, that application will be hard following some very strict timelines. So in fact, for application to preserve the rest, the law provides that, look, between when that application is filed in court and when the court dispenses with that application, 15 days. Then the AMA also went further to say, for appeals as well, provided timelines, very good timelines, short timelines for appeals relating to arbitration to be heard. So all this still go to show how the Nigerian system is now pro-arbitration and pro-enforcement. But that does not mean we've arrived. There are still so many things, issues confronting us, still so many problems that we need to address. For Ghana, the ADR Act of Ghana is also pro-enforcement. In Ghana, any matter that goes to the High Court regarding arbitration takes an average of eight months, which I think is not bad. An average of 8 months. And when it now gets to the Supreme Court, it could get between 3 and 4 years, which of course is far better than what we used to have in Nigeria. And of course can also be bettered if Ghana will introduce into their system, like Nigeria has done, arbitration claims and appeals. For Kenya, interestingly, the Constitution of Kenya recognizes arbitration, makes provision regarding arbitration, and they also have their Arbitration Act, which provides a very effective framework for enforcement. Rwanda is a hybrid regime. In Rwanda, you have both civil law and common law meshed together. Rwanda has a world-class Kigali International Arbitration Center. World-class. World-class. It can meet any standard. The government of Rwanda endorses, and supports arbitration. The judiciary also supports arbitration. And like I said, with their world-class KIAC, that's Kigali International Arbitration Center, Rwanda is becoming a destination for international arbitration. So you see that the problem really is not whether people like Africa or don't like Africa. The problem, like I think Dr. Achi said, if I remember very well, if he's one that says so, or is it Mrs. Shola Oshodijon, the infrastructure. We don't have the infrastructure. We cannot be expecting that people will come and bring their matters to Africa when we don't have good hearing rooms, when we don't have good facilities to support arbitration. We can't expect that. But we have seen that Rwanda has made a whole lot of difference. Egypt also is at the cutting edge. Mauritius is doing very well in this regard, but many other African countries are still lagging behind. Nigeria is pro-arbitration, pro-enforcement, but Nigeria does not have, any structure, any, facilities that would encourage people, to bring their matters, to Nigeria. That is the situation we are in today. So while we acknowledge that Nigeria is pro-arbitration, pro-enforcement, many African countries are now pro-enforcement, pro-arbitration, we must now begin to look at providing those facilities that make people go to Paris, make people go to London, make them go to Singapore, and of course, now making them go to Kigali. Let's now look at enforcement regime in Africa's civil law countries represented by OHADA. Of course, they have an harmonized arbitration.
Dr. Your time is up, but we will give you 2 minutes to please talk on the civil law system, because you notice.
Okay, they have an harmonized arbitration process, but however, they have unharmonized enforcement procedure. That is where they are when it comes to arbitration matters that are not awards that are not CCJA awards. For CCJA awards, the awards are enforced by CCJA's executor, unlike other awards that will have to go through the national court system. Sub-Saharan Africa, the OHADA countries are now cannot boast of being the fastest sub-Saharan African countries, except Rwanda. Don't forget, Rwanda is mixed, is hybrid. So I'm sure Rwanda is already considered joining OHADA. So if Rwanda joins OHADA, it means that the fastest growing economies in Africa today are all OHADA countries. World Bank Ease of Doing Business report of 2020 ranks Mauritius, first in Africa, 13th globally. Don't forget, Mauritius is an OHADA country. And then Rwanda second. Don't forget, like I said, Rwanda is practices a mixed system. Senegal and Cote d'Ivoire are regularly shortlisted as regional hubs for global actors. Other countries' performance further confirmed in the World Bank's projections for 2023/24. An effective dispute resolution mechanism is at the very heart of this. There's no doubt about that. That what we are seeing in OHADA today, in the OHADA region today, is because they have an effective dispute resolution mechanism, a unified system, that is predictable, that is investor friendly. Let me just come to challenges of enforcement of arbitral awards in Africa. Some African countries, notably Rwanda, Egypt, Mauritius, and South Africa, are doing very well. Like I said earlier, as of 2020, KIAC was listed among the top 3 leading institutions in Africa, with 200 registered arbitration cases within 10 years of its existence, and within that period, rendered more than 100 awards, with no single award set aside. Challenges. In Nigeria, lawyers' attitude, delayed proceedings in court. In Kenya, delay in court proceedings. However, appeal from the High Court in Kenya to Court of Appeal is not automatic. And this is where we think we should be looking at. Why must you appeal an award up to Supreme Court in Nigeria, for instance? Why not appeal, not even appeal an award, but appeal a decision relating to an application related to arbitration? Why must it get to the Supreme Court? Why can't it terminate at the High Court? Very easy to do. All you have to do is you make these matters go before an ADR judge who knows so much about ADR. And once it determines that application, it ends there. That will save quite a lot of time. OHADA, the challenge in OHADA is lack of unified enforceability regime across the region for its awards, except the CCJ awards, which, like I said, have a uniform method of enforcement. Then coming to settlement agreements, a settlement agreement is the outcome of a mediation process. A newcomer is a newcomer. Mediation is a newcomer in resolving commercial disputes. Commercial disputes are more amenable, like I said earlier, to a final decision. the world now began to resort to mediation because arbitration became too expensive, time-consuming in many cases. So we now have the Singapore Convention, which has provided a legal framework for enforcing settlement agreements internationally. Only Nigeria in the whole of Africa, has ratified or acceded to the Singapore Convention. I must say, finally, by way of conclusion, there are more good news than bad news. It is not as bad as before. We must know that. We must begin to look at literature based on when they were written. The enforcement regime in Africa is definitely not as bad as before. So much has been achieved. So much good news. More good news than bad news. But still so much to be done. Recommendations. 1, African countries across the 2 jurisdictions should urgently ratify or accede to the Singapore Convention on Mediation. Number 2, OHADA should harmonize its UAA executor procedure. Let it be like what we see in the ICJA procedure that is unified. It can be done. Then law of arbitration and ADR should be a compulsory course taught in all universities in African countries. Countries should, the reason is because so that before they become lawyers, they will know the importance of ADR and not frustrated when they become lawyers. Countries should consider expedited hearings and appeals for all applications that go to court arising from arbitral proceedings. And finally, all applications to court arising from arbitration should be determined by the High Court as the final court. There is no need to ever get to the Supreme Court, not even any need to get to the Court of Appeal. Thank you very much.
Thank you, Dr. Olege. Thank you for that exposition on enforcement. And I quite like the final conclusion that Africa countries are pro-arbitration and pro-enforcement of awards, because this has been one of the major challenges that Africa countries not only have faced, but they have been saddled with, particularly with the perception internationally that when it comes to enforcement of awards is a tall haul in Africa. But we've seen a lot of improvements, and like you said, there's still room for more improvement. So I would like to open the floor for panelists who would like to probably ask 1 or 2 questions or make some contributions to Dr. Olege's presentation. Okay, if there's no comment, and I'll just now look at one word, that one sentence that Olege had raised, and it was like a question for me when he talked about. He did a comparison between the civil law system, particularly among the OHADA countries, and that of the common law. We could see that the civil law countries have been able to come to a place of major convergence in terms of harmonizing their process, which is something that is still not yet done in the common law countries. But I asked myself, is it possible for us to come to a point where we can have a system that is applicable to both or common law countries? Is it possible to come up with something like that? Because I believe that there is a need now for us to have a middle point of where we begin to deal with arbitration and ADR practice in the African continent, if we really are going to make a lot of inroad in this area. So this is the questions and food for thought for us when we come back to the question and answer section. But permit me at this junction to invite my dear friend and sister, the President, Madam President, and George of CJ, Common Court of Justice, Common Court of Justice, to please take us on the topic. She is an expert in this area. I've heard her talk about it severally, and so I know definitely she's going to say a lot here. Comparative analysis of OHADA arbitration system, the common law justice system, and other African arbitration frameworks. She's going to look at them. I know it's extensive, but she would look at it and share insights to what we can do in this area to bridge the gap and come to a place of convergence. Madam President, you have the floor.
Okay, thank you, dear sister. As I hope I will be able to contract my expose as I just have 15 minutes. But as I'm one of the guardians of the system inspired by civil law, you will allow me to make my expose in French. I'm sure the translation is working very well, and you will be very, very satisfied. Is it permitted to make my expose in French?
You go ahead, but we'll ask Patrick, can you please, are you ready to interpret for those of us, for the English-speaking attendees in English?
It is also, what we are doing is also to improve our French and our English. And so I guess English speakers must also be able to learn to speak French. OK, je vais juste, pour le plan de l'exposé, dire, je vais parler du système d'arbitrage OHADA et le rôle de la CCJA. Et je vais faire une toute petite incursion dans la common law, c'est-à-dire en parlant du cas du Nigeria, du Ghana, l'Afrique du Sud, très brièvement, en relevant juste les spécificités. Et après, on sera capable de regarder un peu les autres pays d'Afrique, comment ils font. On a déjà parlé, mes prédécesseurs ont parlé du Rwanda, du Kenya, mais je vais aller dans le Maghreb. Je vais voir un peu, nous allons voir un peu comment l'Égypte, comment la Tunisie et comment le Maroc ont essayé de s'arrimer. On sait qu'ils se développent beaucoup et on va essayer de relever les convergences régionales, quelques divergences et spécificités, les perspectives d'harmonisation et le rôle intégrateur de l'OHADA, parce que, comme l'a dit Chola, le but ici est peut-être d'arriver à se demander est-ce que, rendu où nous sommes, nous pouvons penser à une harmonisation au moins de certaines règles, de certaines manières de faire, une harmonisation entre les pays de la civil law et ceux de la common law. Donc, parlant de l'OHADA, je l'ai déjà dit, à 17 États membres, la mission, c'est d'harmoniser des règles juridiques et de stimulation de l'intégration économique et des investissements en Afrique. L'OHADA a un système d'arbitrage calqué sur la loi type de la CIVI et aussi quelque peu sur la CCI. Le système d'arbitrage de l'OHADA est dual. On a d'une part le système fondé sur le sous-système fondé sur l'acte uniforme sur le droit de l'arbitrage qui a été adopté en 1999 et modernisé en 2017. Cet acte uniforme, qui est une loi uniforme pour les 17 États, offre une base légale commune pour tout arbitrage dont le siège est situé dans l'espace OHADA ou qui implique au moins une partie qui a son domicile dans l'espace OHADA. L'espace OHADA, c'est bien sûr l'espace géographique des 17 États membres. On a d'autre part le sous-système de l'arbitrage institutionnel. Celui-là, il relève du centre d'arbitrage de la CCJA et son règlement d'arbitrage est assez inspiré du règlement d'arbitrage de la CCI. Ce règlement a connu une mutation avec le nouveau règlement intérieur adopté en 2023, spécifiquement le 17 octobre, pour s'arrimer véritablement aux standards. universellement reconnu. Nous avons donc aujourd'hui un système de l'arbitrage OHADA qui est largement inspiré de la NICI, du règlement CCI et qui consacre les principes fondamentaux de l'arbitrage international, notamment la volonté des parties, l'autonomie de la clause, le principe compétence, l'indépendance, l'impartialité des arbitres, les délais de procédure sont mieux maîtrisés, la liberté des parties est consolidée, le principe de la confidentialité est garantie, sauf accord des parties. L'acte uniforme de 2017 a élargi son champ d'application aux investissements. Ça veut dire que dans le système de l'OHADA, les centres d'arbitrage peuvent connaître de l'arbitrage d'investissement et ne plus nécessairement aller au CIRTI ou à la CCI. Donc, des arbitrages basés sur un traité bilatéral ou une loi d'investissement. Mais la particularité centrale du dispositif OHADA réside dans son organe commun, la CCJA, qui siège à Abidjan. C'est une juridiction commune du droit OHADA aux 17 États membres. Et ici, en matière d'arbitrage, elle connaît, cette juridiction, des recours en annulation de sentences arbitrales ou des demandes de reconnaissance d'exéquatur. C'est-à-dire, lorsqu'il y a eu une sentence rendue par le centre d'arbitrage sous l'égide du centre d'arbitrage de l'OHADA, ou alors une décision rendue par la Cour consolidant une sentence venue des centres d'arbitrage dans l'espace, l'exéquatur est communautaire, c'est-à-dire il s'applique et la sentence peut être exécutée dans les 17 États membres. Maintenant, allant des pays de la common law, en regardant un peu le cas du Nigeria, du Ghana, de l'Afrique du Sud, on voit qu'il y a un essor remarquable et des réformes législatives récentes. Pour le cas du Nigeria, on a récemment, en 2023, le Arbitration and Mediation Act qui remplace le Arbitration and Conciliation Act de 2024 et aligne le pays sur les standards internationaux les plus importants. Cette loi se réfère beaucoup au modèle amnistie. L'innovation la plus marquante ici est la création du Award Review Tribunal, c'est-à-dire un tribunal de révision des sentences qui est un mécanisme facultatif, certes, mais un tel mécanisme, on le retrouve très rarement, on le retrouve notamment au CIRTI, qui globalise son système. Il y a également la loi nigériane a également introduit l'arbitre d'urgence avant la constitution du tribunal et a surtout légalisé le financement par les tiers, ce qu'on appelle en droit de l'arbitrage international le third party funding. Lorsqu'on va au Ghana, on va voir l'Alternative Dispute Resolution Act de 2010 qui offre un cadre complet pour l'arbitrage, la médiation et de manière distinctive l'arbitrage coutumier. C'est ça la distinction ici avec le Ghana, cet arbitrage coutumier. Et comme le disait le professeur Olajide, je crois, et le docteur, l'Afrique a une tradition coutumière d'arbitrage et même de médiation. Donc, en introduisant l'arbitrage coutumier dans sa loi, le Ghana n'a fait que reprendre ce que nous connaissons. Il y a également que l'intervention des tribunaux est limitée et là, comme je le disais, l'arbitrage coutumier est une innovation de ce système. Pour l'Afrique du Sud, on voit un système mixte qui est dominé par la common law, certes pour la procédure, mais qui a une tradition néerlandaise en droit substantiel. Cet arbitrage a été modernisé par International Arbitration Act en 2017 et la loi a formellement incorporé la loi type NICI dans l'ordre juridique sud-africain pour les arbitrages internationaux. L'Afrique du Sud un acteur majeur de l'arbitrage international à travers notamment de nombreuses activités et elle agit aujourd'hui beaucoup à travers la semaine de l'arbitrage de Johannesburg. Johannesburg accueille également la Cour africaine de médiation et d'arbitrage de la zone de libre-échange. Et on va reparler de cette cour. Elle n'est pas encore active et instituée, mais il y a de très belles perspectives qui doivent nous amener à une régionalisation de l'arbitrage et aussi nous amener à rendre nos arbitrages internes beaucoup plus forts. Lorsqu'on va maintenant dans d'autres cadres, et qu'on voit le Rwanda, l'Égypte, la Tunisie, le Maroc, il y a beaucoup de convergences et quelques divergences. Par rapport au Rwanda, le docteur l'a dit tout à l'heure, il y a eu une réforme globale du système dans les années 2000 en passant d'un héritage civiliste francophone à un environnement bilingue franco-anglais intégrant beaucoup d'éléments de la common law. Le centre d'arbitrage de CIAC, qui a été institué en 2012, est très, très actif. Et nous avons vu une loi modernisant l'arbitrage et la conciliation qui est inspirée de la loi type de la NUTSI. Donc, on a également une autre initiative depuis le 28 août 2024, un centre de règlement alternatif des litiges en partenariat avec le PNUD et le Legal Aid Forum, inauguré le 28 août 2024. L'Égypte a une très longue tradition d'arbitrage. C'est un arbitrage mixte francophone, c'est-à-dire la civil law, un système hérité de la civil law, mais aussi du droit islamique. C'est l'un des plus anciens systèmes et on a la loi de 1994 qui est relative à l'arbitrage commercial. C'est un système qui est aussi largement inspiré de la loi de la Russie et qui intègre tous les principes, les grands principes généraux. On a un centre très actif, peut-être le plus actif dans notre égrégore, là, c'est le Centre régional du Caire pour l'arbitrage commercial international, le CRCK, qui, avec les règles adoptées le 15 janvier 2024, ce centre intègre l'arbitre d'urgence, le financement par des tiers et les audiences virtuelles et hybrides. Donc, et depuis le 20 mars 2022, il y a une commission qui étudie comment améliorer davantage le système. Par rapport à la Tunisie, c'est aussi un pays de droit civil et islamique d'Afrique du Nord. Le code de l'arbitrage date de 1993 et la réforme est progressiste. C'est également un système qui prend appui sur la loi type de la Russie. Particularité notable, la Tunisie autorise véritablement les litiges impliquant l'État. Donc, pour la Tunisie, la notion de personne morale de droit public ou autre n'existe pas beaucoup. Pour elle, il faut absolument attraire l'État et les collectivités publiques. Ce qui veut dire que lorsque les sentences seront rendues, on pourra également très aisément les exécuter. L'arbitrage de la Tunisie a connu un grand essor, notamment dans des secteurs comme les marchés publics et l'énergie. On a également le CCTA, ça veut dire le Centre de conciliation et d'arbitrage de Tunis, créé en 1998. Et le centre a son premier master professionnel en arbitrage et prospective, ce que beaucoup de nos centres ne font pas. Lorsqu'on regarde le Maroc, qui aujourd'hui se classe dans les pays à développement humain les plus élevés, on voit également que le développement du Maroc s'est appuyé beaucoup sur les modes alternatifs de règlement des différends. Et le corpus a été totalement refondu. On a une loi de 2023 en matière d'arbitrage commercial et de médiation aussi. Et le Maroc forme tellement des arbitres et les avocats que le Maroc a gagné il n'y a pas très longtemps, en 2024, contre le groupe français Infinitis, un très, très grand litige au niveau du CIRTI, ce qui n'arrive pas souvent parce qu'on connaît très souvent nos États. Et le Maroc a gagné son procès pour plus de 300 milliards de francs CFA. Il y a quelques spécificités procédurales qui font quand même que le système du Maroc est un peu critiqué, notamment la procédure des équatures qui est contradictoire. On trouve que c'est un temps perdu et aussi l'encadrement des personnes morales de droit public pour avoir recours à l'arbitrage. Le Maroc est plutôt assez fermé dans ce domaine. Lorsqu'on regarde donc tout ça, c'est-à-dire l'OHADA, les pays de la common law et les pays du Maghreb, on voit qu'il y a beaucoup de convergences régionales. Les convergences peuvent être relevées comme suit. L'alignement est certain sur les standards internationaux de bonne pratique de l'arbitrage. Le partage du principe de la flexibilité procédurale guide l'arbitrage dans tous les centres, que ce soit à la CCGA ici son centre, que ce soit l'arbitrage dans les pays de la common law ou alors l'arbitrage dans les pays du Maghreb. On a le principe de la flexibilité de la procédure. Il y a la reconnaissance claire de l'autonomie de la volonté des parties, c'est-à-dire même dans les contrats, même dans les arbitrages qui prennent leur source, dans les TPI, les traités bilatéraux, l'État ne peut pas reculer parce que sa volonté est bien là. Et on a de plus en plus un rôle croissant des institutions d'arbitrage sur le continent. On a le cas, c'est dans ce cadre que s'inscrivent d'ailleurs les initiatives comme celle du NICArb et toutes les autres. Et on a donc l'émergence d'un socle commun de bonnes pratiques sur le continent fondé sur les standards internationaux tels que la loi type MUSI, la Convention de New York et les règles de l'International Bar Association, IBA. Parce que même si les tribunaux ne le disent pas, ils appliquent ces règles. Maintenant, il reste quand même quelques divergences. On peut trouver les divergences dans les modes de nomination des arbitres. Le droit OHADA privilégie l'intervention du juge étatique d'appui, alors que dans les pays de la common law, les institutions ou autorités de nomination sont de préférence désignées. On les appelle appointing authority. La préférence pour des avocats et experts pour les civilistes, préférence aux juges ou les common lawyers lorsqu'ils doivent nommer un arbitre juriste. Le contrôle juridictionnel de sentence, l'approche de structuration du recours peut être différente. Or, la zone OHADA, il n'y a pas de juridiction supranationale pour unifier la jurisprudence. Ce que fait la Cour commune de justice, la jurisprudence est harmonisée, notamment s'agissant des notions comme l'ordre public procédural ou l'ordre public du fond. La CCJA arrive à harmoniser la lecture de ces notions, ce qui pourrait être une bonne chose pour tous les autres systèmes. La possibilité d'un recours sur le fond, elle est très limite, elle est pratiquement impossible dans les pays de tradition civiliste et dans l'OHADA, et dans les pays de la common law, on voit qu'il y a possibilité de faire un recours lorsqu'il y a des erreurs graves sur le fond. Je n'en dirai pas plus, mais la tendance moderne est de s'appuyer sur la loi type de la MUSI pour qui s'alignent et pour qu'une tendance, une sentence arbitrale ne soit pas revu dans le fond. C'est en réalité vers cela que l'arbitrage international tend. Ne pas revoir la sentence dans le fond. Et il y a aussi la culture juridique et la culture des juges. On a des disparités historiques, comme l'a dit le professeur en début de son propos, mais qui tendent à s'estomper. Il y avait une méfiance initiale vis-à-vis de l'arbitrage en Afrique francophone, alors qu'en Afrique de la common law, ils sont beaucoup plus habitués aux modes alternatifs de résolution de différends dont l'arbitrage international prend réellement son ancrage. Et on voit également des nuances dans la conduite de la procédure. Les habits de la common law sont traditionnellement plus enclins à recourir à des techniques de type common law, comme les audiences, les comptes interrogatoires poussés des témoins, la divulgation des documents plus étendus. Et tout à l'heure, Achille disait que les avocats de la civil law ont intérêt à se rapprocher de ceux de la common law quand il s'agit de l'arbitrage international parce que l'interrogatoire des témoins, même sous la CCI, se fait plus sous le prisme de la.
Yes.
Mrs. Shola, are we hearing?
No, we are not hearing her anymore.
Okay.
I think we've lost her.
Madame la Présidente, vous pouvez voir si votre micro est toujours activé. On ne vous entend plus.
Anyway, our time is up, so we'll just ask her to round up for us. 1 minute. No, not yet.
Are you hearing me?
Yes, we can hear you now.
Yes,
Ma'am,
now we're hearing.
1 more minute to round up, ma'am.
On va voir dans les perspectives d'harmonisation, puisque la zone de libre-échange est entrée en activité, c'est un exemple de coopération sud-sud, nous pouvons très bien voir réduire, combler les gaps entre les deux systèmes. Et ceci est fondamental. Le rôle intégrateur de l'OHADA va être mis en lumière, c'est-à-dire fondement sur un système juridique solide, et voir l'unification du droit des affaires, la sécurité juridique et judiciaire, la facilitation du commerce, la modernisation et l'ouverture progressive. Et on peut prendre de l'OHADA cette exécution des sentences, l'exécution apaisée et aussi une exécution sur l'État qui peut inscrire directement les créances dans le budget. En conclusion, nous pouvons dire qu'en dépit de quelques spécificités procédurales ou institutionnelles, nous sommes sur la bonne voie et nous pensons que cette voie ouverte par le NICArb et l'OHADA va nous amener vers une convergence qui ne gommera pas la richesse des différences culturelles, mais qui les mettra en évidence au service de l'objectif partagé qui est de faire de l'arbitrage un instrument de développement, de confiance, de stabilité et de justice pour le développement de notre continent. Et je vous remercie.
Thank you, Madam President, for that insightful presentation. You always hold it high up, no matter what. And I want to say thank you. I know you've not been feeling very well for granting us the opportunity to glean from your wealth of experience and expertise. Because of time, I would call on our next speaker, George Bayo, to take us through a presentation on the importance of harmonizing business laws across African nations. Before she takes up the floor, I just want to say that Our apologies, I should have drawn your attention to the interpretation button on your screen. If you look towards your right-hand side, you will see a circle that looks like a globe that says interpretation. And so if you are French speaking, you click on the globe and it will pull up two words for you: French translation, French or English, and original interpretation. So if you want to listen to French, you click on French. If you want to listen to English, you click on English. So if you have a French speaker speaking and you're English speaking, click on English, you will hear the English translation. And if you speak French and we have an English speaker making it to our presentation, click on French and you will hear French language. So George Bayo, you have the floor.
Thank you, Mrs. Chola, for giving me the floor. Distinguished guests, dear participants, it's a huge honor and privilege for me to be a part of this high panel organized by OHADA and NICArb. Should I share my screen? Yes. Up. 1 second to share the screen. I can't see anything. Can you see the screen I'm sharing? No.
No, not yet.
No.
Is it better?
Yes, now it's okay.
Yes, it's okay.
So I'm just displaying the key points and then, yeah. Okay, so.
Pour passer à mon diapo.
Yes. Je pense que c'est en mode diapo.
En bas de l'écran.
En bas de l'écran, où ça?
En bas de l'écran vers les symboles de zoom, là. À gauche, à droite plutôt, de l'autre côté à droite.
Oui.
Ouais, encore une fois. Encore une fois. Encore une fois, voilà. Merci. C'est bon.
Okay. So our last discussion will be focused on the importance of harmonizing business law across African states, a perspective through arbitration. This will be presenting in 2 parts. The first part, we'll be talking about arbitration as a tool for promoting business law in Africa. And the second part, the standardization of arbitral practices, a challenge amid legal diversity in Africa. But first things first, let's begin with a quick conceptual clarification. We should be a distinction between harmonization, standardization, and unification. They are all legal integration mechanisms, but harmonization means aligning different legal systems to reduce contradiction. Standardization goes further. It involves adopting the same detailed rules across systems. Meanwhile, unification implies identical legal rules implemented in all member states. So here, although OHADA refers to harmonization, it operates more as a standardization process since it imposes uniform business laws across 17 member states. So the term harmonization, however, is less politically and financially sensitive, making it more acceptable in dialogues between common law and civil law system like the one we are having right now. So why are we pursuing a unifying project for business law in Africa through OHADA? To achieve the 2 objectives of OHADA, behind OHADA's creation, the legal security and the judicial security. And so the legal security is achieved when a unified legal space and modernized legislation, is created, while the judicial security, for the judicial security, the High Court, which is CCGA, ensures consistent interpretation and encourages arbitration. This High Court, as it has been said previously, promotes uniform interpretation and application of OHADA law. And in the space, a training is provided for the magistrates, and also their people are encouraged to recourse to arbitration. So first part, arbitration as a tool for business law. This has been said previously by Dr. Achille Gonza, that arbitration is a tool for promoting business law in Africa. Why? Because the OHADA arbitration law offers a common legal framework ensuring legal and judicial security. So until recently, African state and foreign investors relied mainly on major international centers like the ICC in Paris, the ICSID in Washington for investment arbitration. And then OHADA came up and marked a turning point since 1995 with its treaty and the main instrument, which includes the Uniform Act on Arbitration, the CCGA rules, and the Mediation Act of 2017. So the 2017, since then, since 1995, arbitration has gained recognition as a preferred mode of business dispute resolution. And the 2017 Uniform Act on Mediation further confirmed that OHADA's commitment to ADR mechanism is a real one, a great one, because mediation offers undeniable advantages. And there has been a steady rise since then in the use of ADR mechanism. For example, we have this Togolese center, Kato, where we noticed that approximately 84 cases between 2011 and 2022 have been submitted to the center. Meanwhile, we have the National Arbitration Center in Benin called CAMEC, which has been strengthened as well, because between 2017 for the mediation, 2017 and now 2024, approximately 60 cases has been brought between that institution. So just to say that ADR within OHADA offers numerous benefits and is rising. And this rising should be an economic attractiveness across the continent. In fact, uniform rules build investor confidence. Uniform arbitration rules within OHADA create a consistent legal environment for businesses in 17 member states. And this enhances investor confidence by ensuring procedural predictability and enforceability of awards. On another hand, OHADA instruments reflect international standards, and then by doing so, they increase the region's legal attractiveness. And by doing so, African arbitral centers like as CCGA, KIAC, the one in Rwanda, and Kato, Kamek, these centers are growing stronger and they are more competitive. Obviously, I should say NICArb as well. So all these centers are growing stronger since then, and they are more competitive. So OHADA's experience is a very inspiring model demonstrating how a codified arbitration law can be applied across diverse legal traditions. And I would like to talk about the Article 53 of the Treaty of OHADA, which even allows any African state to join the treaty and then to contribute to the territorial expansion of the organization. And then will come my second big part, standard. Let me go there, okay. Standardizing arbitral practices, a challenge amidst legal diversity in Africa. To say what? Extending OHADA's arbitration model across Africa is challenging. Challenging because of what? Because of the political, cultural, and structural obstacles. In fact, currently, we notice that the political will is really fluctuated in the states. Political resistance persists due to sovereignty concerns of the state because some states resist joining OHADA to preserve their sovereignty, and membership entails compliance with OHADA rules and even CCGA decision. And we notice that some states hesitate to accept CCGA authority. There are some kind of resistance to enforcement of CCGA judgments, which is not really uncommon. I would like to share as a practitioner, I would like to share that case we've been talking about since when I was at the magistracy school, when one of our teachers was talking about that arbitral award in 2005, but this award, which was enforceable and granting full damages and interest to a party versus a state, could never been enforced in the state because the state has shown some resistance to enforce the award. So this is a kind of political obstacle to standardizing arbitral practicing. On another hand, we should talk about the exacerbation of systemic differences because, in fact, common law relies on case law and flexibility, it has been said, and civil law favors codification and formalisms. And bridging these traditions is certainly possible, but we have to say it seems complex. Among the obstacles, we have also cultural challenges. So we notice that there is a persistent preference by people for state justice, partly because arbitration is often seen as costly and elitist. Arbitration, despite all the advantages, people have to pay the arbitrators, and culturally paying for a judge is not widely accepted. And the question of the trust people can have in arbitration centers is a point as well. And another question is a lack of infrastructure in our center, which has been said soon by I think Dr. Odege, he said so. And so these are cultural challenges we have to face to get at the point of standardizing arbitral practices. And on another hand, we should talk about the structural limitation, because in fact, as the chairwoman of OHADA Commission is Benin, we noticed that Currently, the organization is struggling financially due to some states which are not complying with funding obligations. And a larger OHADA would mean more pressure on its organs with potential new members. OHADA's organs will rise up, and then expanding the membership would increase the financial burden if this trend continues. So yes, it will be possible, but the main condition will be that the state should be responsible of the engagement and be paying the funding obligation. And the last obstacle we want to talk about is the perception of dominance. Because what do we mean? Standardizing arbitration through OHADA may be perceived as well as civil law dominance over common law traditions, particularly since common law is often viewed as more arbitration friendly than civil law. Yet, civil law countries like France, like OHADA space today, offer solid arbitration frameworks. And having said that, we can say that a better path forward might be to build a conciliatory and inclusive model, which is the second part of this part. So an inclusive expansion, we can be dreaming of an inclusive expansion. And very soon, or previously, her estimate, Madam the President of the CCGA, I want to quote her, she just said that the main goal should be to try to reconcile what is the best from the both sides because, and this is to quote the MD of ESUMA, because the diversity of the systems are not barriers, but wealth. So we should consider developing African guiding principles on arbitration, for example, to reconcile common and civil law traditions. And a hybrid model could be inspired by the Lex Mercatoria or the UN rules. And we can also think of establishing African mechanisms for mutual recognitions of awards through the whole space, through the whole continent, joint training of arbitrators and stronger institutions would be a strategic compromise for the two systems, common law and civil law system. So to say that we should go towards inclusive expansion by building a bridge, it had been said. So to summarize in conclusion, the development of arbitration and ADR mechanisms is a powerful catalyst for harmonizing business law across Africa. Together, arbitration and harmonization they form a strategic tandem to secure investments and foster legal integration on the continent. But the big question remains. We said that to maximize the impact, Africa should consider a continent-wide harmonized arbitration law, inclusive of diverse legal traditions and different levels of commitment. If so, how are we building that bridge we all agree on to make it functional? Or should interested states adopt OHADA uniform acts individually without a formal accession to the organization? That can be another option as well. Thank you.
Thank you very much, Judge Bayo, for that insightful presentation on OHADA laws and the need for harmonization. The floor is open for panelists that have 1 or 2 contributions to make. But while I'm waiting for the panelists, I just want to touch on 3 main sentences that she raised, which I really asked myself, this is something we need to look at. She talked about OHADA as a model for convergence. I think that's thoughtful. And if I recall, Nigeria was supposed to be part of the OHADA when the idea was mooted initially. But somewhere along the line, we didn't pull through on it. So maybe these are times for us to begin to look at it. And it lines up with the need to have a system that is unifying to both common and civil law jurisdiction in Africa. So there are a lot of questions that are out there for us to take. We'll take them during the question and answer section. But permit me to just provide yield the floor to Professor Olagunju briefly for the next 3 to 5 minutes. I realized that when he was taking his section, because it was the first, there was a lot of rush in trying to get him to go through and all of that. I believe it would be nice for him to have the next 3 to 5 minutes to just round up his presentation, and then we can come to the question and answer section. Thank you.
Thank you very much, and I'm very grateful. I think the points I'm trying to make is that we should think Africa and business. So when we're talking about convergence, we're not talking about convergence in the air. We are trying to focus on issues that affect the viability of the African economy. And I'm using that carefully. Many people see Africa differently, like different countries, different states, but that is not correct. Africa is one. Africa is one. And particularly in terms of dispute resolution mechanisms, the mechanisms we have applied for thousands of years in Africa have been harmonious. There's a very strong convergence in traditional African approaches to dispute resolution. And it is ADR, just putting it simply. And so when we're talking about convergence, we're saying, let us go back to what has been recognized from South Africa to North Africa, from East Africa to West Africa. We spoke the same language. So that's number one. Now, civil law and common law came to us as strangers and interference. And so as good Africans, we must be very careful about letting them make us forget that we are principally one. And so what I am proposing are 2 things. One, that the challenge before us is a political challenge. I know for sure that there are many government representatives on this meeting today, in this meeting today. I am very sure of that. There are some, of course, on the panel. And so they need to listen to what their counselors, their experts, they have trained so much. That's Mrs. Oshodi John said, we have so many trained arbitrators and mediators in Nigeria. Personnel is, forgive me, in Africa, not just Nigeria, in Africa. Personnel is not the problem of Africa. The challenge is let our political leaders know that they have to give leadership. So that's the first thing. Now, what is the direction of leadership so that we can have good business in Africa and so that our economy can come alive? My position, my very strong position before I heard George Bios speak, is that we must embrace OHADA. We must embrace OHADA. I'm happy that Article 53 of OHADA, or the OHADA Convention, welcomes the whole of Africa. We must do that. There's no point reinventing the wheel. They have experience of about 40 years. So let us refashion OHADA. Let's embrace it, but that's only possible at a particular level. Now, at our level as practitioners, I listed several organizations. We need to do what NICArb and OHADA are doing today. We need to come together and work together. the Yoruba say a tree does not make a forest. Let's work harmoniously, no matter what our organization is. Finally, it is true that I said that the foreign legal system are in position, but they gave us something good. Before, we had 3,000 languages in Africa. We still have them. And if you want to communicate across border, we use maybe about 100 languages. But with this foreign languages, English, French, Portuguese, and so on, we're now able to talk to each other in 4. So they brought something good for us, but we must go beyond them and create something new that works for Africa, business, and economy. Thank you very much for the opportunity.
Thank you, Professor Labuju, for the round of your presentation. The floor is open now. I would like that Patrice and our administrators, thank you for the good job you are doing. The floor is open, so we would like to take at least a few questions from the audience, if they are enabled to ask their questions at this time. I believe that Dr. Carol and Professor Labuju had answered almost all the questions on the question and answer box. So, okay. So we have 2 participants that have raised their hands. Can we ask that Joel Kamga, can you please yield the floor to Joel Kamga? Joel Kamga. Patrice, could you unmute Joel Kamga? Joel, you're unmuted. You have the floor.
It seems I've been given the floor. Can I speak? I'm not Joel, I'm Theophile.
Yes, go ahead. You have the floor.
Okay, thank you. Mine is more of a comment than a question. By way of introduction, I'm Theophile Yomde. I sit at the Common Crop and Arbitration. But rather, what I'm going to say is not, please don't link what I'm saying with my position. I just want to put that out. I'm greeting Prof. Olajide and all the panelists. I want to thank you for your contribution. I heard what all the panelists said, and what is coming to my mind is unity and business. The question I was asking myself was, do we want to do business or do we want to do politics? If we want to do business, then let's think about methods to do business. And I'm happy that all the panelists are viewing Africa as a land of business, and the need for us to be unified, and the need for us to look at the different measures and different methods for us to come together. It's not because I'm part of the family, but like Prof. Olajide said, OHADA has proved that it works. If we cannot, because of some difficulties, if we cannot embrace, like he said, or apply OHADA all around Africa, let us come together and see how we can put some rules that defines us, that would enable us to do business. Unlike one of the panelists said about the decisions of the Common Court of Justice, yes, there are some countries that may, because of some sovereignty, be reluctant to apply the decisions or the rulings of the Common Court of Justice. But that is very scarce. I must say that, because the majority, if not all of the decisions of the Common Court of Justice, are being applied and enforced because of Section 20 of the treaty. So yes, can we just not just see as sovereignty and talk business, and sit down and draft some rules that resembles us, so that we can attract business and do business? So thank you to all the panelists, and I wish we continue talking with NICArb and all the other organizations so that we can come together and put things on the table. Thank you.
Thank you, Mr. Joel. Mr. David Adajo, you have the floor. David, you're muted. Unmute yourself.
Okay, are you hearing me now?
Yes, we can.
Good. My name is David Ajaro. I use the opportunity to thank the panelists for the educative section so far. I am a legal practitioner based in Nigeria, particularly Lagos. I am not a certified arbitrator yet. Now, many people view arbitration as a very expensive way of dispute resolution. In fact, many people see arbitration as a channel for business tycoon to settle their dispute. And today, I have carefully listened to a lot of speakers today and how they really want arbitration to even be spread to the grassroots. Now, I have much experience in litigation. For instance, in my community, I am from Delta State. I'm an Urobo from Delta State. In my community, and every community in Nigeria, you will see courts like the High Court, the Magistrate Court, the District Court, and the Customary Court, where even dispute as low as 10,000 can be resolved. What can we do if we really want arbitration to seek into the conscience of majority of Africa? What can we do to bring arbitration to that level where in the community, such as in the community, in the rural area where you have district court, customary court, we can equally have arbitration that can even people who can arbitrate over a dispute of 10,000, 20,000. That is my humble question, please.
Thank you for your question. Dr. Olege, you want to respond to that question, please?
Well, the truth is that arbitration doesn't have to be expensive. And there are different types of arbitration. Investment arbitration definitely will be expensive because it has so much, is involved. International commercial arbitration will be expensive, but we have customary arbitration. So like you just said, in those communities, people can be trained on how to employ customary arbitration. Professor Olagujo is talking about going back to our roots, that, ADR is African, he's always been with us. So in those communities, there can be customary arbitration where the arbitrators can do even pro bono and handle cases of 10,000 naira, 20,000 naira, 100,000 naira. Customary arbitration is the answer for those cases. Thank you.
Okay.
And
Madam President, you want to say something?
Yes, and I just wanted to add that when we go to Ghana law, we can find that they have instituted customary arbitration. So it is not impossible. And never forget that at the beginning, as the professor said, we are African, and that all these our laws and regulation don't really capture all the business fields. They capture just big business, but where the small business are now concerned, these our big laws cannot capture them. Then let us think like African. So last time I went to Gambia, and what did I see? I saw that in the exchanges, they just speak Wolof. It was a very big international event, and even the president, there were many French speakers and many English speakers. At the end of the day, English speakers didn't understand French, French speakers didn't understand English, and at the end of the day, everyone started speaking, how is this English? The Senegalese language.
Pidgin English?
No, not English, Wolof.
The Wolof, yes.
The president of the republic. They just spoke Wolof. And everybody was very comfortable. That is why, as I said before, ce qui nous unit est plus grand que ce qui nous divise. I mean, what we are united with is stronger than what separates us. So let's just build, just like NICArb does every year. We have to stay now and to think about. And what I can agree with is that for Nigeria to enter the OHADA system, we have to work on it. Can an English-speaking country enter the OHADA? Of course. And I can tell you that the Gambia is working on it. Just see the place of Gambia in Africa. It is inside Senegal. How can Gambia do without making a very good relation in business with Senegal? So when we say that, we can now see that we can sit and see defined notions. As Shola said, Cameroon is a very good place to see how common law and civil law can stay together. There was a very big problem with the Uniform Acts, but I think nowadays, the problem tends to be solved just because the English notion, for example, partnership and others, did not really integrate our definition of commercial society. The commercial society est une société en nom, société par action. We have to agree on what is this notion, And the arbitration is a very good example where we can already find a place to be together, knowing that the international arbitration has already many principles. We agree always, and knowing that at the beginning of the day, the arbitration or other ADR were not far from us. We are a continent of arbitration, a continent of mediation. That is in our culture. And when we were last year in Gabon, one of the speakers spoke about the influence of culture in the arbitration. And we saw that when we are in Nigeria, you have to see how Nigeria, because you can actually frustrate someone without knowing that you are frustrating him, just because you are not in the same culture. You have to understand the other, to have a common understanding of notion, a common understanding of practices, and this one we can do it. And I'm sure by bringing on the table this kind of subject, this kind of theme, Shola and the others, Karel and the others will find a way to bring something and to make it easier for us to go further in the partnership. I guess this is the hope.
Thank you, Madam President.
Thank you.
We'll take Abubakar Mwazu Abubakar Muazu, you have the floor. David, please mute your microphone. Thank you. Abubakar Muazu, you have the floor. Okay, if Abubakar is not ready, let's take Mispa.
Hello.
Oh, okay. Abubakar, go ahead. You have the floor.
Yes, thank you, Madam. Almost all the speakers are encouraging the participants the benefits of ADR compared to litigation. Based on experience, is there any blueprint, either in Nigeria or other African countries, how to sensitize the society to embrace ADR against litigation? I have been a public office holder for over 8 years as chief executive. I inherited more than 10 litigations from my predecessors, and most of them are contracts. So every contract agreement, whether it is public projects, they are executed by private practitioners or private contractors. That means a combination of private and public engagement to execute government policies. So it appears there is ignorance on both parties the benefits of arbitration, whereby the slightest default by either of the parties, as you said, they quickly jump and pick a lawyer, finance him, and the lawyers will never like the issue to be taken for arbitration. Both the lawyers and the judiciary, they will prolong something 10 years, 20 years, and in the end, everybody will suffer. So if you say arbitration is expensive, then the number of years you spent in going to court, paying the lawyers, and then you, in the long run, up to Supreme Court, you will not get what you are looking for. So both parties will lose the benefits of arbitration. So is there any blueprint whereby there will be public enlightenment, and also the judiciary should be carried along? The Nigerian Bar Association, for example, I'm a Nigerian, so I'm giving example with Nigeria, whereby NBA and also the National Assembly, who can pass a legislation that there must, if there is an arbitration clause in any commercial business, nobody should go to any litigation unless the arbitration has been exhausted. Thank you, Ma. If I can get further clarification, maybe my colleagues will be happy, because I'm an engineer, not a lawyer, but I'm an associate member of the NICArb. And I joined this NICArb because of the challenges I faced. And I went back and read all the contracts agreements, to the extent that after my training in your institute, I went back and amended our arbitration clause in all the subsequent contracts, that you should not, a contractor should not send anybody who did not understand the contract agreement. And the first thing, a person that will sign a contract agreement should read the arbitration clause first of all, before reading the other technicalities of implementing the contract agreement, or whether it is construction contract or supply contracts. Thank you, Ma.
Thank you, Mr. Muazu. Let me just, if the panelists will grant me the opportunity to take the first shot at this question raised by Mr. Muazu. Let me say that the challenge that we have in Nigeria, I don't know about other African countries, my sisters and my brothers from OHADA would confirm what is obtainable there, is not a question of lack of awareness. That's not the problem. The problem that we have in Nigeria is the intentional unwillingness of members of our noble profession to embrace arbitration and ADR. That's where the problem lies. And so you see a situation where top-level, high-profile lawyers know about the benefits of arbitration when their clients are towing the line of arbitration. They willingly and quickly want to use arbitration to resolve the dispute. But where they find themselves on the other side, where their client is being sued or being summoned to an arbitration hearing, you find them running to court to stop the arbitration proceedings. So that is the major problem for us in Nigeria. It comes from the legal profession. And I think that one of the things that NICArb has been doing is trying to meet with Nigerian Bar Association at different forums and try to get them to see the benefits of arbitration and why they should embrace arbitration. For us, I think we also, as an issue, we moved away from the legal profession because we've seen a strong resistance from them, and we have begun to, court other professionals to encourage them to understand, the workings of arbitration and even take the arbitration training so that they are informed about the arbitration and ADR processes, and they would be able to even advise I have members now that are now advising their lawyers on arbitration. So when their lawyers say, no, let's go to court, there are members that are trained arbitration will say, no, we don't need to go to court. We have an arbitration clause, so we'll use arbitration to try and resolve the dispute, or if possible, even mediation, if the parties can agree. But we've heard you, and as an institute, you can reach out to us, and we can share more insights with you on what we can do to create more awareness at different forums that you have mentioned. So I don't know whether Karel wants to say something about what's obtainable in the OHADA jurisdiction in terms of the question that Abubakar Muazu has raised. I don't know whether it's the same thing you're facing, but for us here, this is the situation.
Yes, thank you, Shola, for calling me on that question. I think we're almost facing the same situation on OHADA space. But what we're trying to do with OHADA is that we use the judges and the official agents, the judicial agents of the space as a key players that could help, in fact, arbitration to be enforced, or arbitration to be the first mode of dispute resolution. In OHADA legal space also, we do have a kind of misknowledge of the pros and cons of arbitration, and people do not provide the good legal advice to the client in order to put or insert arbitration clauses in the contract. It's also sometimes a matter of reputation of the arbitration centers. I have to say that because the arbitration centers sometimes are not that well reputed, and lawyers prefer to be on the judicial jurisdiction and be also able to have some kinds of private deal with some officers instead of coming to the arbitration. They don't know or master more. So that's what I can say. But from the first aspect of the question that I kept in my mind, it was also based on the advantages of arbitration over judicial proceedings. And I think that arbitration from far is a matter of more celerity and also the confidentiality that has been mentioned. And also one have to point out or stress out the fact that when you are in arbitration, you choose your own arbitrators. It's kind of choosing your own judges, even if they are not your judges. You choose to appoint them, and they have the expertise to rule on your case. So these are the advantages I can mention. But from the OHADA perspective, we are highly working on the improvement of the standards of the arbitration centers. Even here in Benin, where the ESUMA headquarters are located, CAMEC is working hard. From Burkina Faso, when you have CAMCO, it's the same thing. And the statistics are evolving, and the national centers are getting more and more files and to rule on. And this is due to the work of OHADA harmonizing and having only one uniform domestic law applicable in the 17 states. That it helps those centers to have more improvement in terms of reputation, in terms of service they gave to the population. That's what I can add, and thank you for calling me on that. Thank you.
Thank you, Dr. Carol. We have Ms. Pa. Ms. Pa, you have the floor.
Sorry, I don't know if I could make a point on what you are discussing now.
Okay, Ms. Pa, just give us 1-2 minutes. Allow Professor Olabuchi to take the floor at this time, and I will call you back on.
So David raised a point, and Muazu has raised a similar point. Basically, they're talking about how do we mainstream arbitration and ADR in our dispute resolution systems. I just want to point out that at the level of Nigeria, there's a new national policy on arbitration and ADR 2024. So the policy is out, and it was issued at the highest level of government. And where they are now is mainstreaming that. And I think when that is effectively done, some of the challenges we are having about how do we assess this justice system that we claim, and rightly too, is superior. Whether we are judges or non-judges, everybody agrees that arbitration and ADR offer succor to people who are in disputes, particularly in view of the need to guard, to safeguard relationship. So I just want to say that policy is there at the Nigerian level, at the highest level, and they are pushing it. Thank you very much. You are muted, ma'am.
Thank you, Professor Olabuchi, for raising that point. I actually even thought about it earlier. I guess it skipped me. Ms. Pa, you have the floor. I've unmuted you. Go ahead.
Thank you. Thank you very much, Ms. Shola. It's always a pleasure to join Nigerian Institute Arbitration Center. Standing on all protocols on this call, it has been a very exciting presentation, the one that triggers further discussions and even other policy-driven areas. I don't have a question, but I have a contribution to make. I am Ms. Pa, the manager of the Chartered Institute of Arbitrators Rwanda branch, and the MD of Awasum Global Consulting Group. I have 2 points to make on this discussion when we talk about harmonization, OHADA, and the common law system. First and foremost, we have to go back to the drawing board, because on several international conferences and even regional conferences, national conferences, we have these discussions ongoing. But there is a progress, but the pace is quite slow than it ought to be. Africa generally is suffering a kind of a colonial problem that I don't think any other person will bring us that solution than ourselves and our sovereign states. The Chief Justice said something that really it pleases my mind so much, but I wish it could go louder and more actions be taken. Let's start from the conventions or the treaties, the international treaties. Talking even of OHADA. Who are the people? I'm a Cameroonian by nationality. Cameroon is a member of the OHADA. Who are those who go to ratify those treaties? We have people from the Ministry of Justice that doesn't really have grips about arbitration. They go and ratify these treaties, they bring them back to us in Africa. We have problems of implementation. Now, even if we say we want to adapt and adopt it into our local laws, how do we adopt and adapt it? In the problem of its adaptability and its adoption, that is where we now have to put the priorities of Africa. Putting into place our cultures, our reality, our economy, our businesses. Now it brings problem of reputation. The way we adapt and we adopt these conventions or treaties into our local laws, it damages the reputations in a way even the African business people do not give that reputation to this practice of arbitration. They do not recognize the arbitration. They feel like they are safer to take it to other international institutions, those big investment or commercial disputes, where they feel that they will have, a secured or more confident arbitrators to sit on them. Somebody made a contribution here that Africa does not have problem of capacity. We have a lot of arbitrators, mediators, But now the reputations, where are the jobs? The jobs are running out of Africa. The second arm of my contribution is we have what we call AFA, the African Arbitration Association. Somebody said we need a blueprint. Engineer, the blueprint is already there in Africa. That is AFA, the African Arbitration Association. I'm a member, and I'm a member of the Young Members Group Committee. We are pushing and pushing and pushing at the level of the Young Members Group Committee. Now we have, for example, under AFA, how many institutions, arbitration institutions in Africa have subscribed to this body? This is a body that we could make it stronger, and then we push our own cause as Africans. But sometimes only us Africans, we feel intimidated by our own regulatory bodies that we have, and we are pushing for continental ones. Might be because we are looking for global recognition or what. So it comes back to us African practitioners to acknowledge, accept, and receive our own regulations, our own bodies. And then by the time we accept it, it's like when you have a baby, you want to see that baby grow. You want to nurture that baby. This is AFA we have in Africa. We have to push AFA. The president of AFA is a Cameroonian, and he is a member of the OHADA board. He practices very well with OHADA practice, Dr. Gaston Kenfa. But where are the African institutions who are members of this association? Now, when even AFA goes to continental presentation, when we are doing institutional arbitration conferences, AFA makes this presentation. You can look at the room. There is no recognition. There is no reputation, because we, the Africans, we have not given it its reputation, the recognition that it deserves. I think from the point of regulation and frameworks, we have to make our framework stronger, have the reputation that it deserves, and whosoever, I don't used to like calling colors or race, will be able to recognize our own institutions, because nobody will give us that recognition, but we will champion our recognition, and we will be on the same table. The AFA conference is coming in Nairobi in October. This is time for other institutions. Yes, Dr. Ms. Shola.
Please, could you just round up, please?
Yes, so I'm rounding up. I'm rounding up. Thank you. So this is just to say that let us team up, join our own regional bodies and make it stronger. And then why not we set up an African Court of Arbitration stemming from the African Development Bank? These are things we have to work on as African practitioners. While the institution, that's the states, they have to ensure that the bar associations make it a policy, a norm for lawyers to be able to complement arbitration and not fighting with it against litigation. Thank you very much, Mrs. Sola.
Thank you. Thank you, Ms. Fa, for your contributions. I just wanted to address one or two things you said. It's important that we clarify that. AFA, NICArb is a member of AFA. And I think right from, I think the second year of its inception.
Amazing.
But let me say on this platform that there are problems. And the problem is that AFA's term of reference is not well defined. AFA cannot come in, want to be a unifying body and be competing with national bodies, bodies like ESUMA and others. So that's one of the problems that I see there. There needs to be, AFA needs to go back to the drawing board to really be restructured to be able to play the role of being a mouthpiece for Africa, but not compete with the regional and national bodies that are already existing, that are already doing a lot of things that AFA now is duplicating. We don't want duplication. You talked about the African courts. There's no need for that. We have CCJA. Well, let us look at, we're talking about convergence, we're talking about building bridges, and let us, whatever is already working, the systems we have that are already working, let us adopt them and look for a way to strengthen them and come together as one to, give Africa a voice. It doesn't pay us to have so many centers, to have so many bodies, so many courts. It's not easy it is for us to even not have a voice. But where we have unifying structures on ground, let's adopt them. One of the reasons why we are doing this conference is to say that OHADA under CCG under OHADA, ESUMA, NICArb have a lot of common areas that we can work together on, build on, to the point where we get to a stage where some of even the laws that we say this is common law, this is civil law, we can harmonize them. We can come up with structures where we work across borders. That's what we're looking for. So that's the problem with AFA. AFA needs to go back to the drawing board to clarify its term of reference. AFA will not be able to thrive, let me put it like that, if it's competing with national and regional bodies. It would not work. So that's the problem I see. I don't know whether I'm the only one that has this view, but that's what I have noticed. And also, that's one of the reasons why I would say that we are not very active in AFA. Initially, we wanted to, I was at Kigali. Yes, I was at Kigali. When they had the second conference in Kigali, I was there. But when I saw the way it was being driven and we had to pull back. That's what happened to us.
No,
So,
yeah.
I don't know what
Yes,
Madam President.
What I want to say at this level is that we have to act with what you have, indeed. And we have to call upon the politics. Because one of the attendees were asking Joel Mba, please, let's just talk about Africa and business, not talk about politics. But what I want to say is that everything at the end of the day will become politics. Why? Nous avons le NICArb, nous avons les humains, nous avons... Quand on regarde aujourd'hui, pourquoi il n'y a pas une réelle explosion des modes alternatifs de règlement de différends, nous voyons que il faut que nos États, d'abord, prennent en main la question. Nous allons travailler, nous sommes des techniciens, mais il faut cette volonté de rejoindre les autres, d'œuvrer ensemble. Il faut cette volonté. Le traité de l'OHADA le dit. Il dit l'arbitrage est le mode par excellence du règlement des différends. Mais lorsqu'un État lui-même doit aller en justice, il saisit lui-même ses juges. Parfois, alors qu'il y a même parfois, par rapport à un traité ou une convention, il y a une clause d'arbitrage. Mais les États préfèrent se réfugier derrière leurs juges. Donc, il faut une volonté politique, il faut enseigner, et là je rejoins Chola et Karel, enseigner davantage, enseigner, parce qu'il y a beaucoup d'ignorance. Il y a encore beaucoup d'ignorance. Autre chose, il faut qu'on arrive dans les spécialités. Il faut que de plus en plus d'arbitres soient spécialisés, qu'ils soient véritablement dans le concert des arbitres, qu'on les cite comme des références. Pour cela, il faut publier davantage, il faut mieux se faire connaître. Donc, il y a des structures, des associations, comme a dit la femme, de l'autre côté, il y a la PA, il y a ces initiatives. Elles sont encore très peu solides. Nous avons déjà des choses solides, comme le NICArb, comme les SUMA, comme bref, des supports solides. On peut agir à partir de ça. Et je suis sûre que d'ici 1-2 ans, le NICArb et les SUMA et l'OHADA en général auront, je propose de créer un comité ad hoc qui va réfléchir sur cette harmonisation et comme ça, on va travailler là-dessus de manière à voir qu'est-ce qui est réellement bon. Il faut certes garder l'arbitrage institutionnel et autres, mais l'expérience du Ghana est très intéressante quand ils vont dans l'arbitrage coutumier Et quelqu'un l'a également dit, je crois que c'est Davis, il a dit l'arbitrage tend encore, et le juge l'a dit aussi, l'arbitrage paraît encore l'élitiste. Ramenons l'arbitrage, payons des services peut-être arbitrage coutumier et mettons en place une plateforme ou un comité qui doit travailler sur les avancées possibles et pour faire à aux structures décisionnelles des propositions concrètes ou des partenariats plus avancés. Parce qu'on ne servait à rien de s'asseoir tout le temps sans avancer. Je propose qu'à la sortie, au sortir de ce webinaire, nous ayons une plateforme qui va nous aider à avancer davantage. Et peut-être, dans un prochain webinaire, on va voir quelles sont les avancées possibles. Merci, Shola.
Thank you, Madam President. I will take the last comment from the floor. Olumide, last comment from the floor, and then we'll bring the webinar to a close.
Okay, I was about to give it. Okay. If Olumide is not ready yet, maybe I should can I make a point?
Yeah, sure, go ahead. Go ahead.
Thank you, Shola. So I totally agree with Madam the President of the Court about the process. I think, in my opinion, we should work hard on the policies and legal framework, because at this point, we have many centers who can do the job in Africa. And maybe we have to make the ADR almost compulsory in certain cases, like if the executive executive public power, if they are ready to strengthen the ADR, then maybe we can go on working on policies and legal framework to make ADR compulsory in certain cases. And that will help to give credibility to our centers. People will get used to ADR, and the option named by Mrs. the President in Ghana, which is arbitrage coutumier, is a very good one. But we have to make it compulsory for people to not have that choice, because if they always have choice between the public judges, litigation, and ADR, maybe sometimes they will go straight to the public judges. But if in certain cases then we made it compulsory, they won't have to be concerning by the other side. So a training with the key actors is also a solution to trust in the system, and that will help people to be aware of ADR mechanisms. So that was my point. Thank you, Shola.
Judge Bayo. Briefly, just permit me to summarize all that we have said in this, I think it was five panels, including the welcome remarks by Dr. Carol. Permit me to just summarize it briefly for those that were not opportune to join us earlier. Number one, summary of the webinar is that we should embrace the elements of both civil and common law systems in our practice of arbitration and ADR across Africa, and that adoption of UNCITRAL model law and the New York Convention, adopting and ratification of both has provided the civil law and common law systems a common area for us to explore to forge a uniform practice. And thirdly, African institutions must work together to implement these conventions that are already existing. So meaning we should build from what is already existing, build from the known to the unknown. And then fourthly, Africa should engage on UNCITRAL, see how UNCITRAL can adopt its traditional dispute resolution mechanism as part of the UNCITRAL model law. I think it's something we need to push for not just only embracing what they have, from top down, but also we should export what we have and sell it to them as well. Then we talked about the need to form synergies towards utilizing the capacity within the African continent in handling international arbitration, which will help improve the arbitration and ADR practice of Africans at the international level. And then we talked about having an effective dispute resolution mechanism is the heart of attracting trade and investment that will lead to progressive growth in our various economies. And we saw that with the slides from Dr. Olege showing that OHADA countries are actually the fastest growing economies right now in Africa. And we talked about the need for us to also ensure that there's progressive growth in our various economies if we begin to improve on the ADR environment, increase in business and investment will apply to individual countries. And we talked about the need to adopt bilingual languages. This was from Madam President in the part of arbitration and ADR, because she gave an illustration about how the Kigali Center has improved greatly with their ability to also use both French and English in their hearing center. The flexibility is also important. The processes that we have, we need to be flexible about them, and we can begin to adopt them to replicate working procedures that we have noticed across different systems, so we can have optimal performance across board. The main goal for us is that we adopt what is best in both the civil and common law systems across the African continent. And we need to consider coming up with a guide or the best African principles across both jurisdictions. We also talked about common law mechanisms. We should come up with common law and civil law mechanisms that strengthens award, recognition of award across board, and recognition and enforcement of awards. The need for us to be inclusive and also reconciliatory model in bridging legal traditions. And this is from Judge Bayo. So a lot has been said today, but I just briefly jotted down these points for us to take away from this webinar. And I want to sincerely, on behalf of Madam President, President of CCGA, and my brother, Dr. Karel, the DG of ESUMA, my dear panelists, Professor Olajide Olagunju, all the way from the US, Ms. George Bayo, thank you so much, all the way from Cotonou, our next door neighbor and brothers and family. And I want to thank Dr. Olege. I can't see Dr. Olege right now. I also want to thank sincerely all the people that worked in the background. Without them, we couldn't have had this webinar, because it took a lot of effort from them to help us get through with the translations. Thank you so much, Patrice. Thank you, Patrick. Thank you, dear, is it Modesta? One of the interpreters from ESUMA. I want to say big thank you to you, because he's bereaved and he ought to be in Cameroon right now attending to funeral arrangements, but he's here with us. I want to say a big shout out to you for giving us your time to make sure today's webinar was well conducted. And thank you to all our distinguished attendees and contributors to today's webinar. This is the first series of webinars that the three organizations are going to be putting forward to. And just like Madam President has said, after this webinar, we're going to go back to the drawing board and come up with a few of the things we think we want to work with in trying to achieve this goal of harmonizing the various arbitration and ADR practice across the African region. And I want to say thank you. Also, we're also planning a training. We want to also have a training on both civil and common law jurisdictions that will address civil and common law jurisdictions issues, so that we can have arbitrators that are trained in both jurisdictions, so they can also be able to practice under OHADA and also practice under NICArb. And last but not the least, to say that I haven't had the opportunity to sell NICArb or promote NICArb on this platform. But let me now say that NICArb is not just only training, but we also have an arbitration center, and by the grace of God, we've done a lot. I can tell you right now, we are we are handling one of the highest arbitration matters in Nigeria, involving, I wouldn't mention the names, but 2 prominent organizations in Nigeria right now running into billions of dollars. So we are coming. So let's not give up. We are coming, and we're definitely going to get there. If we keep pushing, we will not allow politics to stop us from the goal that we started with, which is to see that we have a common voice, that we're able to own our space and tell our own stories. And I look forward to, in a few years from now, like Mifspa said, see young practitioners from Nigeria, from Cote d'Ivoire, from Cameroon, from Benin, Togo, and all over Ghana, doing so well, representing us so well. I'm looking forward to the day when we will no longer ship arbitral matters out, but that arbitrators that are homegrown and homebred in Africa will stand out there and speak on behalf of Africa and represent us so well. So thank you everyone for making today's webinar a very interesting and impactful one. I mean, clap for yourself, everyone. We've spent 3 hours on this webinar and we have not moved. So thank you, everyone. You have all stayed consistently, listened to all the panelists and every one of us. So I say a big thank you, and thank you, everyone, for your time. Have a wonderful day. Bye-bye.
Congratulations.
Bye-bye. Thank you.
Thank you, Shola.
Thank you.
As someone said, you sold the NICArb at the right and sharp time.
Oh yeah, I did. I did too. So have a wonderful day, and we'll converge again. All my panelists and speakers involved in the first planning meeting. We will send out notices to all of you, and we can meet and progress from just what we have discussed today. But some of the highlights we have raised, we will look at them and come up with a front. And thank you, Madam President, for your support. We appreciate you.
Thank you.
You have a wonderful support and a good weekend. Bye-bye.
Enjoy your weekend.
Merci beaucoup et bonne soirée à tous.
Vous aussi. Bye-bye.
Bye.
Bye all.